Work until you no longer have to introduce yourself. You know who said that? Harvey Specter. And that's arguably his most famous line from the smash hit series Suits, based in New York.
Why do you need me?
Now, why am I thinking of Harvey Specter and Suits? Well, that's because foreign lawyers and foreign law firms are the talk of town. In a huge move aimed at liberalizing the legal services sector in India, the Bar Council of India has permitted foreign lawyers and foreign law firms to practice in India with riders on a reciprocal basis. This was announced via a Gazette notification. Reciprocal meaning, if your country allows an Indian lawyer to practice in your jurisdiction, then we shall grant your lawyers the same privilege in our country. Seems fair, right? Now, to break down the significance of this landmark move, which is likely to change the entire landscape of the legal sector in India, let me divide this explainer into 3 buckets. Why did the Bar Council do this? What are some of the key takeaways in the fine print of the Gazette? And finally, what could be the impact of this historic move? So for starters, what was the trigger? Now, the opening of the legal sector in India has been a move that has been broached in the past. It's had its fair share of ups and downs, faced opposition from different quarters and lobbies, and even faced litigation at the High Court and the Supreme Court. But now, finally, it's a reality after years of uncertainty. So what's the rationale of the Bar Council of India? Well, the Bar Council of India, according to the Gazette, was of the opinion that opening up the legal service in India would in fact go a long way in helping the legal profession and the domain grow in India to the benefit of lawyers in India too. In fact, the Bar Council of India goes on to emphasize, let us ensure then an opportunity for creating development and growth for legal profession and in the legal sphere in India is not lost. So clearly, the Bar Council of India believes that in an era of globalization and an increasingly interconnected world, the time has finally come to take the plunge.
I think the opening up of foreign law firms to practice foreign law in India is a very positive step. It'll help us, general counsels and other users of service providers in India of foreign law services to have the lawyers in the same jurisdiction, in the same time zone, have face time with us. It'll help us execute deals better, and will help grow the Indian economy. So all in all, I think it's almost a necessary step as the Indian economy grows.
They also highlighted that the move was unlikely to create any sort of disadvantage for the legal fraternity in India, as the law practice was being opened up very carefully in a restricted, well-controlled and regulated manner. And they also said the step would be mutually beneficial for lawyers from India and abroad. 2 additional benefits were pointed out. The Bar Council of India believes that opening up the legal sector in India would address concerns on FDI inflows and also the concern around making India a hub of international arbitration. And finally, they point out that many countries have allowed the same opening based on the principle of reciprocity. Hence, they are following best global practices. So that's the trigger. Right. Now let's examine the fine print. And as they say, the devil is always in the detail. Firstly, registration with the Bar Council of India is mandatory for foreign lawyers and foreign law firms to practice. No registration, you're not going to be entertained. Now, how long is this registration period valid? It's valid for a 5-year period. It can be later renewed. Importantly, registration can be denied by the Bar Council of India based on the reciprocity or the proportionality principle. So the final call will rest with them. Now, here comes the first of the 2 most important riders or restrictions. Like I said earlier, it's been introduced, but with certain restrictions. Here's the first and most important limitation or restriction, so to say, for foreign lawyers and foreign law firms under the new regime. Now, foreign lawyers will practice law in India in non-litigious matters only. That's what the rules say. Now, what does the word non-litigious mean? Well, it means legal services that do not involve the commencement or conduct of proceedings in any court or tribunal. Basically, this means not relating to litigation. Here's the second important rider or restriction, and this will provide a certain degree of comfort to any nervous local lawyers. The rules say that foreign lawyers can advise on issues relating to countries other than the Indian laws only, which means they can advise only on foreign law or international law. Let me specify that once again. They can practice in India, but they can advise only on foreign law or international law and not on Indian law. That's a big factor as part of the fine print. Here are a few other restrictions. Foreign lawyers are not permitted to appear before courts and tribunals. Work relating to conveyancing of property and title investigation is not allowed. So you must be wondering, what is allowed? Well, here's what's allowed. Foreign lawyers are allowed to work on M&A, that's mergers and acquisitions, joint ventures, intellectual property, drafting of contracts. So all that is allowed. All that corporate commercial work is allowed. Foreign lawyers and foreign law firms can also partner with each other under the rules if required. Registered foreign law firms can open offices in India. Well, that means physical presence finally for them. Interestingly, these rules by the Bar Council of India are silent on any M&A or alliances between foreign law firms and Indian law firms. And finally, what will be the impact of this historic move? Most of the managing partners of leading corporate law firms have welcomed this move from the Bar Council of India, calling it progressive. They feel it will spur healthy competition, provide better, deeper exposure to global best practices, also improve technology and modernize the entire sector. They feel it will give a chance to work even more closely with their foreign counterparts. And let's not forget that foreign clients will always prefer having their legal eagles on the ground in India for an important deal or a transaction. Of course, on-ground presence matters a lot. The move also opens the door for dual qualified Indian lawyers based abroad who can now come back to India and practice in the new regime. Home sweet home, after all. But what are some of the concerns? Well, one concern that has sprung up is, what if foreign law firms indirectly or surreptitiously practice Indian laws, which is not allowed under the rules? Well, if that fear is valid, then greater vigilance would be required. The second concern is, the rules state that if the Bar Council believes that a foreign lawyer or a foreign law firm is guilty of professional or any other misconduct, then the case will be referred to the disciplinary authority of the concerned country. A senior corporate lawyer told me, why should the case not be dealt locally instead? That was his concern. Finally, it will be interesting to see the impact on client fees and, of course, overall salary levels. Now, which will be the first foreign law firm to take the bait? When will the Baker McKenzie's and the Clifford Chances of the world enter India? Will there be any tie-ups or any partnerships between Indian law firms and foreign law firms? Well, for now, it's too early to make a prediction on these aspects as the dust has barely settled. With that, it's a wrap from me, Ashwin Mohan. Stay tuned to Moneycontrol for more news, views, and updates.